Good morning, Alex Woods here, civil litigator, and I have had a number of complaints about waffling on and making these videos far too long. I make no apologies for that, but as a concession, this week's concession is I'm going to keep this posting extremely short. The answer to this question is yes. By way of illustration, I'm just surrounded by papers here with an insolvency practitioner who's asked me for a little bit of advice on how to deal with a case. The facts of the case are as follows. Mr. X is in an IVA. He has made a PPI claim to Welcome, now owned by the FSCS. He hasn't informed his insolvency practitioner that he's doing this. Welcome have then adjudicated in his favour, and very quickly after having adjudicated in his favour, have acted in a way that Welcome, at a pace at which Welcome isn't known for acting, or the FSCS isn't known for acting, and has set the claim off against the loan. Of course, you may all know that Welcome has been a bit of a mess because of partly because of the PPI business, and is now basically being run by the Financial Services Compensation Scheme, and they are unsurprisingly wanting to shore up their loan book by doing things such as setting off successful PPI claims against the loans. All right. So they then discover that Mr. X is in an IVA and notify the insolvency practitioner, my client. They inform the insolvency practitioner that they're going to set off the case unless they hear from the insolvency practitioner within 14 days. A horrendously short amount of time to act unilaterally without the authorization of the IVA supervisor. So, quite simply, I have been asked, and I have drafted a letter in response to Welcome, who have not heard back from the insolvency practitioner within the 14-day period, and a month after notification have set off the claim. So I have written back to Welcome. Now, it really is common sense. It's under the 2008 IVA protocol. Therefore, you could argue about the meaning of section 17.6 and spend a lot of money on lawyers doing so. What does repayment mean? Is a PPI refund a repayment? But instead, I choose to look at the particular circumstances of this case in conjunction with that point, I have to say. And I note that the form that Mr. Halford has filled in to make his claim states that he only became aware of the existence of his PPI as a result of going to the IVA, pretty much after he had gone into the IVA. That made him aware of the possibility of making a claim. I've lost my microphone. I then find a modification in the IVA proposal which categorically states, once the IVA is set up, if Mr. X comes into any money, then Mr. X has to pay those proceeds into the IVA, and that paragraph of the modifications immediately is in capitals. So the letter I draft to Welcome simply states that, as a general principle, it is inequitable that any creditor should be preferred over another creditor, and instead they should make an unlawfully sold PPI refund available to all the creditors, and that they will get their share of that refund when a dividend is made. For my money, that's the general starting point. Moreover, in the individual terms of Mr. X's IVA, provision is made for refunds for monies that come into the possession of Mr. X after the IVA has been set up. Refer to the relevant paragraph. Furthermore, having taken legal advice, our strong view of the interpretation of Section 17.6 is that PPI refund is not a repayment, and that when they drafted that clause, they weren't aware that a PPI scandal was in the offing. It's happened. Let's take an equitable view. The other thing that's interesting to note about this particular IVA is that Wellcome are by far the minority creditor to Her Majesty's Revenue and Customs, who are by far the majority creditor. And therefore, in all the circumstances of the case, the right approach is to pay that PPI refund into the IVA. If you need a lawyer to draft the clever lettering, as I say, it's important to be robust with creditors on the set-off issue, and my experience is generally they will see sense and capitulate. There endeth what is probably the shortest video bulletin I have ever done. If you've got any further queries, please, I'm still looking forward to someone posting a first comment on my website, at least an intelligible comment. So I'm very welcome to receive your comments. Watch this space, because fingers crossed I shall shortly be authorised to create havoc as my own law firm, the SRA willing. Many thanks, and I look forward to posting to you in future.